To claim a fiduciary relationship exists, though, they have to prove either that was an agreement to act on behalf of the owner or to act as the agent. And again, the agreement does not have to be in writing. It can be established by the conduct. Or there's obviously a fiduciary relationship as a matter of law. So the mere placing and trust in another does not create a fiduciary relationship. If that's the case, almost every contractual relationship involves some type of trust and confidence in the other party. So that's really not enough. Because, I mean, that's pretty much what the courts have found, is that every contract would be a fiduciary relationship. It was just trust and confidence was all that was required. The key factor is the control of the person over the property of another. Is someone making a decision based on solely, not their own judgment, solely on the judgment that you're providing them? That's what you have to ask yourself. Is a city, for example, going out and spending $100 million based on your advice? If that's the case, then you have to be very careful about advising the city about all the risks attendant to making that decision. And that comes to the duty of disclosure. You have a responsibility to explain the risk, the cost, and the alternatives to doing something. If all those disclosures are made and you make a mistake, that's a little different. That then brings it back to a negligence cause of action and not necessarily a breach of fiduciary duty. So the problem with all of this is that for engineers, this is a question of fact on whether a fiduciary relationship exists and whether it was breached. And there's a possibility of punitive damages. So here's the problem. It goes to a jury. If this is brought up and it survives a summary judgment or survives demur, a jury is going to decide whether you acted as a fiduciary or not. And this is really, I think, the greatest danger for engineers, because once a jury gets involved, if they see reliance, that probably is enough for them. They're not going to get into the weeds very much on some of the technical issues. You're going to have to be able to show them, we told them the risks. We told them that this outcome was possible, and this outcome did happen. You have to be in a position to say, we've advised them of the risk. But remember, a jury would decide, and also, to make it even more scary, it's potential that these are non-dischargeable debts because somebody acting in fiduciary capacity may not be able to discharge this type of debt in a bankruptcy situation. I'm not trying to scare you. I'm just trying to say this is why these fiduciary obligations are very important not to get involved with. Also,
I have no problems with you scaring us. That's fine. We need to be scared, so go right ahead.